Hi, I'm Dr. Kylie Burns from the Griffith Law School, and today in this third of a series of 3 videos we're going to talk about what happened after the snail in the bottle and where Australian product liability law is now. So this is the third in a set of 3 videos about Donoghue and Stevenson and Lord Atkin. The first video by my colleague Professor Mark Lunny described the history and context of the famous case of Donoghue and Stevenson. And in the second video, Kit Barker from the University of Queensland talked about Lord Atkin's contribution to legal reasoning. But what happened after Donoghue and Stevenson? And that's what we're going to talk about today. So in this video, we're going to look at what happened in Australian product liability law in relation to manufacturers' liability following that really famous case of the snail in the bottle, Donoghue and Stevenson. So we start really soon after Donoghue and Stevenson, and we start with something that may seem quite weird to you, Woollen Underpants, in a very famous Australian case which came just a few years after Donoghue and Stevenson. And that's the case of Grant and Australian Knitting Mills Ltd. Now this case concerned Dr. Grant, and he was a fairly well-known medical specialist in South Australia. And in June 1931 he bought some woolen underwear from Don Martin & Co, which was a department store in Adelaide. And that underwear had been manufactured by Australian Knitting Mills. He took it home and within a few weeks he began to wear it. So he put on the first set of unwashed underwear and he wore it for a week, which may seem weird to us now, but apparently that was quite normal at around that time. Within about 9 hours though of putting that underwear on, he began to itch and scratch and his ankles started to get sore. Very quickly he developed dermatitis. After a week, he put on a second pair of underwear and he wore those for another week. Then he put on the original set, which by then had been washed, but by that stage, the dermatitis had spread. Now over time, unfortunately for Dr. Grant, the dermatitis became very severe. When he went to see a medical specialist, the medical specialist suggested to him it might be the underwear that was causing the problem and perhaps he should take it off. Now, despite not continuing to wear the underwear, the dermatitis spread and spread until almost all of his body was covered by dermatitis and he got really ill. In fact, he was ill for over a year. He was hospitalised for months and at some stages it was said he might have almost died. Now, by the time the case came to court, Dr. Grant said his dermatitis was caused by sulfate chemicals, which were present in those woolen long johns as a result of the manufacturing process. So he sued both the manufacturer and the supplier. Today we're really more concerned with talking about the manufacturer, Australian Knitting Mills. Now this was quite a famous trial. It went for 20 days in South Australia, which was one of the longest civil trials in history in South Australia. It was really heavily reported in the media. And he was ultimately successful, with the court finding in his favour and granting him damages. But very quickly after that, Australian Knitting Mills and John Martin appealed to the High Court of Australia. And what happened there in the High Court of Australia? Now, unfortunately for Dr. Grant, in that case he lost. And let's talk a little bit about that. So 3 judges in the High Court said that he couldn't prove his case in negligence. Only 1 judge held for Dr. Grant. 2 of the judges, Justice Dixon and Justice McTiernan, said the problem was Dr. Grant had not proved that the sulfate from Underpants had caused his dermatitis. Justice Stark, on the other hand, also holding against Dr. Grant, said there'd been no breach. Now it turns out that the manufacturing process for this woolen underwear was pretty much the same as manufacturing processes used by other clothes manufacturers. Justice Stark said there was no real evidence, and there had been extensive evidence given about the process at trial, that anything had been done unreasonably by Australian Knitting Mills. The important thing to note, and here we come back to Donoghue and Stevenson, is that none of those judges said that the duty of care, which we have talked about in the previous videos from Donoghue and Stevenson, didn't apply in this case. They didn't have to consider it finally, and that's because they said Dr. Grant failed for other reasons. Justice Evan dissented. He would have found for Dr. Grant, holding, just like we discussed in the previous videos, that a duty of care was owed by the manufacturer, here Australian Knitting Mills, and that the evidence as accepted in the trial court in South Australia should also be accepted in the High Court of Australia. Now again, pretty quickly there was an appeal up to what was then the highest court of appeal for Australia. Now that was the Privy Council, an English court. Now, this is just a little note in history, but the Privy Council actually existed as Australia's highest court of appeal in some form right up until 1986. What happened when the case got up to the Privy Council? Now, it's important to tell you that on the Privy Council sat law lords who also sat on the House of Lords, and you might remember that the House of Lords is the court that heard the original Donoghue and Stevenson case. Well, very luckily for Dr. Grant, finally up in the Privy Council, he eventually won his case. Now, why is this case important? Well, it's important because it's the first higher court decision in the Commonwealth to expand the ratio of Donoghue and Stevenson. And you might remember in the video that Kit Barker produced in this series, he talked about the ratio of Donoghue and Stevenson and the reasoning in Donoghue and Stevenson. Now, really importantly, what did the Privy Council say about Donoghue and Stevenson and how it applied to Australian law? It said that the ratio or the finding or the principle that manufacturers owe a duty of care to consumers that was held in Donoghue and Stevenson also extended to Dr. Grant's situation. They said the presence of the chemical in the pants due to negligence in manufacture was a hidden and latent defect. Dr. Grant could not have seen it. It was just like the remains of the snail in the bottle that we saw in Donoghue and Stevenson. It couldn't be detected by any examination that Dr. Grant could reasonably have made. So importantly, what we have there is an extension of the duty of care owed by manufacturers to consumers into Australian law. The Privy Council also said that this duty of care owed by manufacturers wasn't just restricted to items in food and drink, like, for example, the bottle of ginger beer. But what about breach and causation? And you might remember the High Court of Australia had held, in the case of one judge, that it couldn't be shown that the manufacturer had done anything wrong, that they'd acted unreasonably in the manufacture of the underpants. And in the case of the other two judges in the majority, that causation couldn't be shown. And that's because those two judges in the High Court said there was conflicting medical and expert evidence. It was just too uncertain to say whether or not it in fact was sulphite that had caused that dermatitis all over Dr. Grant, or whether he was just predisposed, internally disposed to get dermatitis. But in the Privy Council, the judges held that the breach and causation findings in the original South Australian case shouldn't be disturbed. That the fact that very soon after Dr. Grant put on those underpants, he suddenly developed dermatitis gave us grounds to think that in fact a breach must have occurred, that is, there was sulphite in the underpants, and that sulphite must have been the thing that caused the dermatitis on Dr. Grant's body. So the coincidence of time and place and the absence of any other explanation for the presence of sulphite in the garments points strongly in favour of the plaintiff's case, said the Privy Council. So, where are we in Australia 80 years or more after Grant and Australian Knitting Mills and Donoghue and Stevenson? Now I want to talk to you about the state of the law now and where it's come and how it's so much more complex now, but yet we face some of the same problems that plaintiffs suffered back in the days of Grant and Australian Knitting Mills. Now the first thing to note is we still have the common law of negligence in Australia. However, we now have a lot of legislation that also has to be considered. That's statute-made law, law made by Parliament, and that modifies, adds to and affects the common law of negligence that we've been discussing in the last few cases. So the common law, that is the law of negligence, duty, breach, causation and damage that we've discussed, interacts with these pieces of legislation, has to be considered together with legislation in order to prove those elements of negligence. So, just like in those days of Grant and Australian Knitting Mills and Donoghue and Stevenson, A plaintiff today who wants to sue a manufacturer because a product is defective still needs to show duty, breach, causation and damage to bring their negligence action. But they might also need to consider the civil liability legislation in every state, because there are restrictions of varying kinds in that legislation that might impact their claim. And really importantly, for a case like Donoghue and Stevenson, there are caps and limits on how much money a plaintiff can recover, particularly when they've got a more minor claim where they haven't been severely injured. So in Queensland, that piece of legislation is called the Civil Liability Act, but all states and territories of Australia have similar, although not identical, legislation that would have to be considered. But in that period of time, after Grant and Australian Knitting Mills and over those 80 years, it became apparent that negligence didn't always work well in product liability actions. So you might remember that Kit Barker mentioned in the last video the cases that arose after the widespread damage caused by the drug thalidomide, where babies were born with very severe abnormalities after their mothers took the drug thalidomide during pregnancy. It became clear in a range of product liability cases, for example, that it might be very difficult for a plaintiff to prove that a manufacturer had breached their duty of care, that they'd failed to take reasonable care. So around 1992, in Australia, following international action on product liability, stricter statutory product liability actions were introduced. Now, the actions in Australia are now contained in the Australian Consumer Law in Schedule 2 of the Competition and Consumer Act and apply across Australia, including in Queensland. That doesn't mean negligence is gone, because plaintiffs can still sue in negligence, sue manufacturers if they suffer an injury from a defect in a product, but they can also bring an action under the Australian Consumer Law. What are the benefits of doing that, you might ask? Why would you do it? What you're about to see in a moment is one of the main benefits of taking action under the Australian Consumer Law is that a plaintiff doesn't have to prove that the manufacturer has failed to take reasonable care in manufacture or has breached their duty. However, there are still restrictions in the Australian Consumer Law. So just like in the restrictions I was talking about a moment ago in the civil liability legislation, in the Australian Consumer Law and under Part 6(b) of the Competition and Consumer Act, there are also restrictions on bringing an action or recovering compensation when a plaintiff hasn't suffered very severe damage from a product. Let's focus on the main important action under the Australian Consumer Law as it might affect someone who suffered an injury from a product like, for example, ginger beer or Woollen Underpants. So, under Section 138 of the Australian Consumer Law, there's a statutory stricter cause of action where a person is injured as the result of a particular product. So you can see a manufacturer of goods has to compensate an individual if they supply goods in trade or commerce, if the goods have a safety defect, and we'll talk about what that is in a moment, and where the individual suffers injury because of that safety defect. So you might remember I said before, one of the advantages of a statutory product liability action is there's no necessity for the plaintiff to show that the manufacturer failed to take reasonable care. All they need to show is the manufacturer supplied goods to them, the goods have a safety defect, and that they've suffered some injury because of the safety defect. So what is a safety defect, you might ask? Under Section 9(2) of the Act, for the purposes of the action we've just talked about, goods have a safety defect if their safety is not such as people are generally entitled to expect. So, for example, you wouldn't expect to have a rotting snail inside a ginger beer bottle. You wouldn't expect that woolen underwear would contain lots of chemicals or sulfite in them that might irritate your skin. Now, there are a range of things, though, that might cause a safety defect in products. So, you might look at the manner in which they're used. It might be their packaging. It might be that the instructions aren't sufficient, that people aren't given adequate warnings about the side effects of using a product. So, for example, a drug or a pharmaceutical. What are the potential side effects? How could they impact you? What's the dosage you might take? It might be those things which cause a safety defect. So would Mrs. Donoghue's action be successful today based on the discussion we've just had about where Australia and Queensland law is now? Well, first of all, it's hard to tell because we really don't know the full facts of Donoghue and Stevenson. You might remember from the video that Mark Lunny made that the true facts of Donoghue and Stevenson were never tried in a court. Although the House of Lords sent the case back down to the trial courts to make findings about those facts, what happened was that Mr. Stevenson died before that could be done and the matter was settled. So we just don't know. We don't know, was that snail ever in the bottle? How was the bottle manufactured? Were there adequate precautions taken to make sure snails didn't drop into bottles? We just don't know. The other really important thing we don't know is how severe the injury was that Mrs. Donoghue suffered. So you might remember from video number 1 that the damage Mrs. Donoghue alleged she suffered was gastroenteritis and severe shock at finding that rotting snail in the bottle. But did that last a few days? Was it severe? Was she hospitalised? Did it last for months? Could she not work? We just don't know. And maybe that was a less severe injury. Maybe the gastroenteritis cleared up after a few days. Maybe the shock wasn't a recognised psychiatric disorder. We just don't know how severe the injury was. So it's hard to tell whether it would be worth taking action today. Really importantly, what we do know is you still have to prove causation in statutory action. So you still have to show that the safety defect is linked to the injury suffered by the plaintiff. Now, perhaps if you could prove the snail was in the bottle and that the manufacturer should have made sure the snail didn't get there, maybe Mrs. Donoghue could have easily shown a link between that snail and drinking the ginger beer around the snail and the injury she ultimately suffered. But if we think about Dr. Grant's case, that might have been more difficult. There was unclear and contested expert evidence, and the High Court certainly felt that perhaps he couldn't show causation. That might be a problem today. Importantly, whenever we talk about bringing a legal action today, we have to think about, is that practical? Would it actually happen? Why or why not? Now, the problem for Mrs. Donoghue is, if that wasn't a severe injury, if it was a minor injury and she was well after a short period of time, the modern legislation, the civil liability legislation, and also the modern statutory product liability provisions that we talked about before really limit or prohibit recovery for less severe injuries where someone has recovered very quickly. Perhaps that would have been Mrs. Donoghue. The other thing, of course, in a practical sense is it's very expensive to bring civil litigation. One thing we know about Mrs. Donoghue is her case was quite special because when it went to the House of Lords, in order for that to happen, Mrs. Donoghue got what in those days would have been a form of legal aid. The House of Lords declared her to be a very poor person, and that allowed her to bring her cause of action in the House of Lords without suffering the consequences of costs orders. Now we know that civil litigation can be very expensive. That might be a big deterrent for someone like Mrs. Donoghue. Well, what could Mrs. Donoghue do today? If she couldn't bring legal action, if she couldn't prove the case, what could she do? Well, what we have now in Australia in relation to food safety is a complex regime of local, state and federal legislation that makes sure food is safe. So it applies to cafes, restaurants, businesses that manufacture food. So today, if someone like Mrs. Donoghue got a snail in her bottle, she'd probably ring the council or the local health department and make a complaint. The factory might be investigated, an inspector might be sent out, they might be fined. So, the end of our tale is we don't quite know what Mrs. Donoghue would do today. We don't know at the end of the day enough about Mrs. Donoghue. But we do know something about Dr. Grant. So whatever happened to Dr. Grant after he successfully sued up there in the Privy Council for his Woollen Underpants? Well, it appears his story ended well. He lived to a ripe old age, well into his 80s, and it appears he never again suffered dermatitis in the manner that he did after he wore the itchy underpants. So maybe, just maybe, it was the underpants after all.